after being certified fit to work be enough to claim total and permanent disability benefits? What if you're told you're fit, but no one wants to hire you back? This is the 92nd case out of the 160 cases decided by Associate Justice Mario Lopez, chairperson of the 2024 Philippine Bar Examinations. Hit that subscribe button and get notified about our latest content. Watch our videos to increase your chances to recall these doctrines and concepts. This is the case entitled Dale Filman Manning Agency Incorporated, Dale, IOM, Limited, and Captain Manolo T. Gacutan vs. Jose N. Gatchalian Jr. GR number 207507, promulgation date, February 17, 2021. Jose N. Gatchalian Jr. had been a dedicated chief cook for Dale Filman Manning Agency Incorporated and its principal, Dale, IOM, Limited, since 2002. His life took a dramatic turn in June 2006 when he signed a 9-month contract and boarded the M/V Independent Endeavor. What was supposed to be another routine stint at sea soon became a nightmare. On December 4, 2006, while performing his duties on board, Gatchalian suffered a severe accident. His left foot slipped, causing his right kneecap to strike the iron deck forcefully. The impact led to unbearable pain, and his knee never quite recovered. When the vessel docked in Antwerp, Belgium, Gatchalian was examined by Dr. R. Verbist, who referred him to an orthopedic specialist at St. Vincentus Hospital. The diagnosis was grim: a tear in the medial meniscus and a fractured osteophyte. He underwent surgery on December 6, 2006, and was declared unfit for duties on board. Subsequently, he was medically repatriated to the Philippines on December 12, 2006, for further evaluation and treatment under the care of the company-designated doctors.
Back home, Gatchalian continued his treatment. By February 14, 2007, after multiple physical therapy sessions, the company-designated physician assessed him and declared him fit to work. The doctor noted significant improvement in the strength and stability of his right knee. Satisfied with the recovery, the physician certified that Gatchalian could return to duty. However, things didn't go as planned. Gatchalian was never rehired by Dale Filman or any other company. After almost 2 years, on February 11, 2009, Gatchalian filed a complaint against his former employers, seeking total and permanent disability benefits, sickness allowance, damages, and attorney's fees. His claim was anchored on a new medical diagnosis issued by Dr. Angel Chua of St. Luke's Medical Center, dated May 18, 2009. Dr. Chua diagnosed him with traumatic arthritis and recommended a permanent partial disability classification, contradicting the earlier fit-to-work assessment. The case first landed at the Labor Arbiter's (LA) office, where Gatchalian's complaint was dismissed. The LA ruled that the company-designated doctor's assessment was more credible since he had attended to Gatchalian from the time of repatriation until he was declared fit to work. Gatchalian's independent physician, who saw him only once nearly 2 years later, was not given much weight. Despite dismissing the complaint, the LA awarded Gatchalian PHP $150,000 as financial assistance. Gatchalian appealed the decision, but the National Labor Relations Commission, NLRC, affirmed the LA's decision, though it deleted the financial assistance award.
Dissatisfied, Gatchalian took his case to the Court of Appeals, CA, which reversed the NLRC's ruling. The CA ruled that Gatchalian was entitled to permanent total disability benefits, reasoning that his injury, diagnosed as traumatic arthritis, was work-related. The CA also noted that the failure of Dale Filman to rehire Gatchalian after he was declared fit to work cast doubt on the reliability of the fit-to-work certification. The CA awarded Gatchalian $60,000 in permanent total disability benefits, sickness wages, and attorney's fees equivalent to 10% of the monetary award, issue before the Supreme Court. The primary issue was whether the Court of Appeals erred in granting permanent total disability benefits to Gatchalian despite the company-designated doctor's certification that he was fit to work.
Decision of the Supreme Court. The Supreme Court ruled in favor of Dale Filman, reversing the CA's decision. The court emphasized that the company-designated doctor's assessment of Gatchalian's fitness to work, made within the 120-day period prescribed by law, should be given more weight. The court pointed out that Gatchalian failed to follow the mandatory procedure for contesting this assessment, specifically, the referral to a third doctor, as stipulated in the POEASEC Philippine Overseas Employment Administration Standard Employment Contract. Since Gatchalian did not seek a third doctor's opinion, the findings of the company-designated doctor were binding. Moreover, the court highlighted that Gatchalian's failure to be rehired does not automatically prove disability. The law does not require employers to rehire seafarers after their contracts end, and non-reemployment does not constitute evidence of a disability. The court reinstated the NLRC's decision, which denied Gatchalian's claim for permanent total disability benefits. If you were in Gatchalian's shoes, would you trust the company doctor's assessment, or would you seek another opinion? And if your employer doesn't rehire you, does it automatically mean you're disabled? Let us know your thoughts in the comments below. Save this video to your favorites for future reference, and don't forget to hit the subscribe button.
Important doctrines discussed. 1. Fit to work assessment prevails. The company-designated doctor's assessment, made within the prescribed 120-day period, is binding unless contested through a third doctor's opinion, which is mandatory in case of a disagreement. 2. Non-reemployment does not prove disability. The non-reemployment of a seafarer after being declared fit to work does not automatically entitle the seafarer to disability benefits. Employers are not obligated to rehire employees after contract termination. 3. Mandatory third doctor referral. If a seafarer disputes the company-designated doctor's assessment, the dispute must be referred to a third doctor agreed upon by both parties. The third doctor's findings are final and binding. To stay updated on crucial legal information that could save your life someday, make sure to subscribe to our channel.